Away from that, the Attorney General of the Federation and Minister of Justice, Prince Lateef Fagbemi, has issued a stern warning to state governors defying the Supreme Court's ruling on local government autonomy. And speaking in Abuja on Thursday at the 2024 Annual Conference of National Association of Judiciary Correspondents, Fagbemi threatened to file contempt of court charges if the disregard continues. The Supreme Court, in a landmark judgment on July 11, 2024, upheld the financial autonomy of Nigeria's 774 local government areas and barred governors from controlling funds met for the councils. Now, it also mandated the Accountant General of the Federation to remit allocations directly to local government accounts, declaring the previous practice unconstitutional. However, more than 5 months after the ruling, the federal government is yet to implement the directive, prompting concerns about compliance with the Apex Court decision. And to unpack this, we're joined by a legal practitioner and CEO, House of Justice, Gloria Ballason. Good evening, glad to have you join me on the program.
Thank you, and it's a pleasure to be here.
Okay, let me kick off by asking what your thoughts are regarding the threat by the Attorney General of the Federation, as well as the Minister of Justice, warning that state governors should not defy the Supreme Court decision or ruling on local government autonomy.
Well, what we expect is not a threat, but an actualization of what the Supreme Court delivered in its judgment of 11 July 2024. The Attorney General of the Federation is the Chief Law Enforcement Officer of the Federation. He is also the counsel for the public. And so if a landmark judgment like the one delivered on the local government autonomy has not been obeyed, then it's not a question of threat right now. It's that the Supreme Court, which is a policy court, cannot deliver a judgment, and then what will happen, as we now see, is a situation where state governors are even going as far as enacting laws and passing bills to countermine the judgment of the Supreme Court. When this kind of action happens, what we call for is mass chaos. And it's ironic that we have the state governors debating the existence of the local government, but they do not want the existence of the state debated. The same constitution that guarantees the existence of local government also guarantees the existence of states and governors as well. And so it's important that when the Constitution has made its design, the Constitution being the expression of the will of the people, and the Supreme Court as a policy court decides on a decision, then it's important that that decision should be respected. And so to speak directly to your question, we want to see the Attorney General of the Federation move from threats to activating the machinery of the law to enforce the judgment that was delivered on the 11th of July, 2024.
I know you talked about it's not a matter of threats, but then action. I'd like you to expatiate a bit further regarding the Supreme Court's ruling when it comes to local government autonomy. How should they ensure compliance on that verdict?
The law has its own, there are laws for the enforcement of judgments, which can be activated, and that's a basic thing that happens with the legal system. But I think more troubling is the fact that after the Supreme Court delivered this judgment on the 11th of July, we're having governors openly coming out to act as though the judgment of the Supreme Court ought not to have been delivered. For example, the governor of Oyo State has called for homegrown, in quote, solutions to the issue of local government autonomy. I don't think that that is open to his own opinion. I think that once the Supreme Court has made a decision, the next thing that we should see is the implementation of that decision. We have also seen, as in the case in Anambra, that Section 13(4) of the bill around the local government has been activated. They are now refusing a situation where the local government will have its own autonomy. In fact, in Anambra State, the governor has signed that bill into law, and that flies in the face of a judgment of the Supreme Court that has already been delivered and is existing. And that's actually contempt of court. And it's important that the Attorney General looks at it from that tangent with a view to implementing. But again, we saw a mass action by the governors. You would recall that Nigerians went to the polls to have their local government elections a few months back. What we saw is that in all the states, what they delivered was 10/10. Governors just decided, they picked and chose who they wanted as local government chairmen, which means that the governors themselves, do not respect the tenets of the democracy that brought them into their offices. And it's quite unfortunate. It's even more unfortunate where we have some of these governors who were part of the effort to bring democracy into existence, being the people at the forefront of ensuring that this judgment is not respected or complied with. So I would say that it's important that we have a total overhaul of the actions of these governors as regards their contempt of the judgment that was delivered on the 11th of July 2024.
I'm talking about governors, Gloria. Let me touch on the immunity granted to governors themselves. How do you situate that with the impact it will have on enforcing Supreme Court's ruling on local government autonomy?
For a long time, the advocacy has always been, particularly for those of us in the civil society group, that when a governor, a deputy governor, a president, or a vice president willfully disregards the law, flaunts the law, then we shouldn't have the Section 308 availing for them. If you have no respect for the Constitution, then the Constitution should not defend you. In any case, having sworn to uphold the Constitution, and then the governors will then go ahead to do what they're doing right now, which is not obeying the Constitution and leading the people to set up what looks like law but is illegality against what the decision of the Supreme Court does, should not avail them the cover of immunity. But I think the wider implication of what we're dealing with is that we have a situation where leaders assume that they can be above the law, and that the people who have decided that they want the local government should be beneath the law, which I think is unfortunate, that we would have governors be the ones lead in the subjugation and the undermining of the Supreme Court. It's a serious issue that needs to be looked at and reviewed.
Now, still talking on local government autonomy, what do you foresee could be the storm brewing or challenges, on the way when it comes to directive on local government autonomy? What really are the chances of success, for such a challenge?
There was the decision that the accountant general will pay the funds directly to the local government coffers. Unfortunately, more than 5 months after, this has not been implemented. So even the federal government itself has not even helped in this decision of ensuring that the local government carries out its duty in the autonomy that has been provided by the Constitution. I do not see what the challenge is because there has been a lot of fears by the state governors around the autonomy of local government, as though the states would not exist without the local government. If the states can exist independent of the federal government, then the local government should exist independent of the states as well. What we have seen is that it's taken quite some time for us to have proper local government elections. And I think also we need to be speaking with the electoral commissions, both the State Electoral Commission and INEC, around why it seems like the local government election is an afterthought. Because if we're able to give it the kind of primacy that we give to elections for the governors, for the House of Reps and the Houses of Assembly, we'll probably not have the discussion that we are having right now. So I do not see any fallbacks that there could be if we have a local government autonomy. What it just means is that government gets closer to the people. The state governors themselves will have to now sit up to look for other ways to have funds and to run the states effectively.
And that's a fine place
rather than just exist in the realm of fear, it's important that we respect the law and we move towards its implementation.
That's a fine place to anchor it. Thank you so much for your expertise on the news. Gloria Ballason, legal practitioner, CEO, House of Justice. Many thanks indeed.